What's up, everybody? We are back with another episode of The Lawyer You Know and breaking down the latest hearing in Karen Reed's case as the Commonwealth tries to strike another expert or at least have the opportunity to make that argument in front of the judge. And they have some things to say about this expert that make you think they don't really believe what he has to say. And he may just be a hired gun picked by Karen Reed's defense team, drinking the Kool-Aid, saying whatever he needs to say to help Karen Reed. Methodology, experience, expertise, forget about it, throw it out. He's going to say whatever they want him to, are the type of allegations, among other things, that Hank Brennan had to say about this expert. But the judge had some very interesting comments at the end of the hearing that give us a pretty confident lean as to what she's going to do in this situation. So we're going to try to take a guess at what we think the judge is going to do and what the next steps are, because things are moving fast and furious towards an April trial date in this case. Make sure you guys hit the like button. Let's get into it. All right. We have this hearing that we are going to go through in Karen Reed's case. I am going to mention off the top that the first part of the hearing was a motion for reconsideration, basically on the fact that Judge Cannoni was going to allow the Commonwealth to get the reporter's notes for an interview done with Karen Reed. And he made an argument, and basically at the end of the argument, he just said, basically, you're stepping on the First Amendment. You're going to ruin her career, because if she's a reporter, that her reputation becomes, well, her notes are going to get out there. She's going to lose her integrity. She's going to lose her sources. She's going to lose confidentiality. Nobody's going to want to work with her again. And at the end, the judge did something differently. She didn't necessarily change her opinion. She said she'll take it under consideration, but she did say that the reporter does not have to include the notes about her thoughts during Karen Reed's interview, just containing conversations with the defendant. And the lawyer argued that could be intermingled, Judge, and that's problematic. He doesn't even want her to have to reveal that. But if that's what it gets limited to, and the Commonwealth said they're fine with it, whatever the judge limits it to, a good lawyer can make a lot of arguments that certain things are the reporter's notes and thoughts to herself and shouldn't be disclosed. So it'll be interesting if that becomes something that we litigate in the future with this case to determine what does or does not get turned over. Then we talk about the ACA experts. And at this point, the Commonwealth said that they reached out to the feds. The feds provided a response that was insufficient, and the defense needs an opportunity to review that response and respond. But we're going to try to get that stuff set over in the next couple of weeks, because there are multiple days that the court has blocked for hearing time. And at one point, Hank Brennan says, "I'm always available, Judge," which makes me think this is literally the only case he's working on, which is pretty wild to me, but that's what it seems like is the deal here, that this is the case that he is focused on. So then we get to Mr. Green, the Google/forensic electronic expert, and they want to exclude two things. The Commonwealth wants to exclude the opinion that Haslong to die in the cold was not Googled at 2:27 a.m. and that it was not deleted. Those are the two main opinions that they want out. And they explain that he doesn't explain enough of his methodology. They make some arguments that are just not good arguments that make no sense. Like, Judge, his opinion has not been subject to peer review. His opinion has not been reasonably accepted in the scientific community. It's like, it's not the opinion, it's the methodology, it's the way he does things. And if his application is totally off, sure, but just because he reads the data to say a certain thing doesn't mean that that's how you challenge it for the Daubert-Lanigan position that the Commonwealth is taking at this point. But then a lot of what Mr. Brennan did when he got up here to argue in front of the judge was take shots at the defense and this expert as to what their MO is, what they do, and how this is just another piece in the puzzle that they're trying to pull to distract, to point the finger at all these other people with no evidence. And it's very peculiar, the changes that were made in the defendant's affidavit. And I also found it funny because the Commonwealth, or the defense, argued that one of the Commonwealth's witnesses' affidavit was also very strangely changed. And the Commonwealth was like, it was just a supplement. No big deal. It was just a supplement. But let's hear what Hank Brennan had to say about this witness's change in affidavit.
Mr. Green has filed two affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now, that is odd, because usually a professional knows what they do for a profession.
So the fact that he changed what he called himself or what his status was, he's like, that's odd, because usually if you're a professional, you would know what to call yourself.
Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit, for example.
So remember, he said that when this expert used technical terms, they were wrong in the first affidavit, and he changed them now to be right. Remember that he said that. That might come back as a little counter move for the defense.
Well, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense.
So here we go with his explanation. And he does it throughout the hearing, that he is an advocate for the defense, a hired gun who is going to say what they want him to say. And that's dangerous, Judge. First off, expert witnesses are supposed to be neutral. They're supposed to evaluate and they're supposed to testify. But they always testify for one side or the other, I guess, with the exception of the ACA experts that were actually hired by the government and then testified for the defense in this case. But generally speaking, when you choose and you hire and you pay an expert, usually that means they're going to have a favorable opinion. You kind of already know that going into it. Sometimes you don't know. Sometimes you ask them certain things. Sometimes you have a consulting expert, but that's not unusual. And that's exactly what the Commonwealth's expert do. So to say this as if it's going to disqualify him as an expert makes no literal sense to me at all. I don't get why he would even make this argument to be like, he is way too in favor of the defense, Judge. It's like, yeah, it's a defense expert witness.
When we look at his affidavit, there is quite a bit of advocacy, insinuations, and surmise, and conjecture, and claims that have no factual basis. But there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation.
And it's wild to say that, right? I'm not an expert. I don't know anything about computers really, but to say there's no factual basis for that at all, yet we've all seen the piece of paper from the report where it says deleted. Now, that might not mean deleted, or at least that might be the opinion of some experts that that's not deleted, but at least you've got to say like that's some evidence or something for him to base it on. It's a good faith basis for him to have that opinion. It's not like it's not like he said all these other bad things were also deleted. It's like, but there's nothing that says they were deleted. In his own affidavit, he spelled his name wrong. Are you talking about Brennan or are you talking about Green? Dorothy said, was there ever a ruling on the verdict forms from the last trial? I don't know. I haven't seen any additional post-trial motions on it, but the court made the decision and everybody agreed, including the lawyers in the last trial, to send those verdict forms back. So I'm not sure if that's what you're asking.
Similarly, when we look at his affidavit, it is replete with accusations suggesting but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not true.
So he's mad that they said there might be some manipulations or tampering with evidence. By the way, for anybody that thinks this court sound is not great, I have it boosted as much as I can, number one. Number two, I've been listening to ASAP Rocky's trial all week, and that is some miserable court volume. So enjoy this and appreciate it, even though it might be a little low.
The role of a forensic examiner, unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common view in the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. Mr. Green is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used.
So then he gets into some of the technicalities about the tools used, which ones his experts use, which ones the defense's experts used, and how more isn't always better. Green is kind of picking and choosing what he's relying on. He'll call support, and if they say something good for Karen Reed, he uses it. If they say something bad, he doesn't use it. All of that is good for Cross. Good for Cross. I'm not saying Hank Brennan can't make those arguments. That is not what we are here for in a Daubert hearing. Honestly, I have thought Hank Brennan has done really well at certain aspects of this case. I really have. Some people have disagreed with me. Come at me about it. That's fine. I think he has done really well, and I think he's going to do significantly better at trial. And we're going to mention at the end what the Commonwealth is already setting up with this trial that I think is going to be a significantly better presentation than the first time. But this was horrible. Like, I just think all of these Daubert motions, I'm really like, gosh, I really feel like this is a complete waste of time. And it starts to be like, man, what are we doing? Why are we even making these arguments? I don't think that this is the strongest lawyering we've seen out of him in this case. All right, we'll talk about when he starts saying an expert shouldn't be able to say this could happen or couldn't happen. He should only say things that are absolute, basically, is what this sounds like to me.
Is an attempt, really, to surprise at his second opinion is an attempt, really, just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because, number one, it doesn't have any resonance. Somewhere.
By the way, it's not me freezing. It's just this court feed froze a few times as I was watching it live too.
Uncommon. The claim, or the opinion number two, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number.
So no factual basis, and an expert's ever going to opine something like this. It's different when one side says this is impossible, this couldn't have happened, for an expert to say no, physically or scientifically or electronically, it could happen. I don't know that it did, but it could happen. That is an appropriate testimony to make, depending on what the arguments are on both sides. Number two, is there no evidence that police would have manipulated the phone? I don't know. They've got a lot of evidence that they can point to that looks shady from law enforcement, number one. Number two, they had the phone for a period of time with the passcode before they really did any of the official work on it or documented work on it. I think there's at least things there that they can make those arguments to the jury. And again, this is going to be something that the jury's going to have to determine, and not the judge striking this witness. The last commenter said, how dare the defense put on a defense? Exactly. That's what this is. They should be allowed to. They will be allowed to, in my opinion.
Number two, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated.
I actually thought, when I read the expert's affidavit, I thought he was giving the McCabe's kind of the benefit of the doubt almost. Not the benefit of the doubt. He was definitely positive for Karen Reed. But he was saying, like, I'm not saying the only way this could have been deleted is by manual deletion, right? Or manipulation by the McCabe's. I'm going to say there's 4 or 5 ways that this could have been deleted. That one seems to line up with the most with what we have and what we downloaded from the phone. It was kind of as simple as that. And again, he acts like there's no way he could ever come up with this testimony.
Then rehash that manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It's because the claims he makes in opinion number one are so scientifically and forensically unsound. This is attacked to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make this objection. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact and data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it happened, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do, they match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. Most expert witnesses would do that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories.
So he gets into the fact that the Commonwealth witnesses kind of tested it. If you do this on a phone, how does it turn out? He didn't even do that. Well, let's see, because if he didn't, that's a good way to say your expert witness opinions are better than his. But it's not a reason to strike his opinion altogether. That's what all of this is. So I feel like I'm repeating myself a little bit. When we listen to the defense, we're going to skip a lot of their arguments that say that exact thing because we've been saying it the whole time. I almost called him Lally. Brennan went through the Lanigan factors and didn't really talk about, how these actually fit into the Lanigan factors. Because to me, he kept talking about his opinions or his interpretation, not his methodology or the way he got there or the things that he does. There's a little bit more. We'll listen to a little bit more of this clip and then we'll move on to the defense's argument. He does say that Green is a vessel for the third-party culprit defense. Basically, the defense is trying to circumvent the judge's ruling and still get into the third-party culprit defense. And he makes an argument at the end of his argument, which is not going to be in this clip. That's a pretty good evidentiary argument about what the testimony and the evidence lines up to why this 2:27 a.m. search never happened, but it really happened at 6 o'clock when we have EMTs saying Karen Reed said, hey, can you search this and using this? That's a great argument. Make that a trial to the jury. That's not going to get this opinion struck. Not how it works.
If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just pause it, hand grenades throughout the case, and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims.
I mean, he feels like he's done that. I know you might not like it, but it feels like he's done that. So then we get to the defense. They talk about how qualified he is, how he's more qualified than the Commonwealth experts. Opinions are not a reason for a Lanigan hearing, which we've already kind of discussed. But then I thought he did it. I really like Alessi. I'll just say, I really do like Alessi. He went into, he's really good at the motion practice in these hearings because he goes into Whiffen, one of the Commonwealth's expert opinions, and does such a great job of saying, Judge, these experts are doing exactly what experts do. They do the same work and they come to different opinions somehow. And they've got to explain and convince the jury why the way they see it and the way they did it is correct through the mouth of a lawyer.
Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Dalbert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was.
So Whiffen said, that's correct. 227 is the time shown in the database. It's important to take this step by step.
Indeed a deleted record, but within the database. It was indeed a deleted record.
So even the Commonwealth's expert said it was a deleted record. Now he explains why that's not really what it means. It doesn't mean they manually delete it. That's fine. It's all fine. The Commonwealth's expert can absolutely do that. But for Brennan to say there's nothing in the record or evidence to ever come up with these opinions, it's like, man, that's going to, unfortunately, again, the jury's not listening to all this, hopefully. But that hurts me in the future when I listen to his arguments. The fact that you can make such a bold-faced argument like that just to me is a miss. It will make me struggle. So I'm gonna have to push through and still try to remain and see the good that I saw earlier in him, because I do think he made some really good arguments and presented really well. And I do think he's smart. I think he's crafty. I think he's tough. So I do think it's going to be a different vibe, but I really did not like a lot of the arguments he was trying to make today.
But the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So,
because you're not going to get an expert to say this is an absolute fact, and anybody that says it the other way is dead wrong and they must have done it wrong. Now that the Celebrite report has changed and the data has changed mysteriously, but it has, will Whiffen and Hyde take that strong of a stance that this is dead wrong? This is exactly an absolute false fact, not true, couldn't be, can't be. Are they going to change it, or are they going to continue to say this is my opinion? Because I don't know a lot of experts that like to go any stronger than this is my expert opinion with the data and information I have and that I tested.
So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that search and that record that everybody saw at the time of trial at 22740, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 22740. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 22740 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion.
So a couple good comments coming through. Asia said, Peter, could it just be the fact that he's a defense lawyer and his standard practice to make every viable argument, no matter how weak, LOL, benefit of the doubt? I don't, honestly, it's not even an LOL. I think it's a good point. And you're right. Defense lawyers make all these defenses to protect the record, and I understand. Now, if you're going to go be a special prosecutor, I understand you're still a defense lawyer, but you have to look at it a little bit differently. So it is different. It's not as much of a protection of the record, in my opinion. But when I read this, I said, okay, let me think about it that way for a second. And just off the top of my head, I do think one of Brennan's attempts here of what he's trying to do is, because he mentions it later in the hearing, that the defense's MO is to bring up all these crazy conspiracy theories and the Commonwealth has to waste all their time knocking them down. We're not going to do that anymore. He does not want to do that at trial. I do not think that is going to be their theory and their theme at trial, like it was for Lally's trial, to defend all these other people the defense is accusing as opposed to prosecute Karen Reed. But what is he doing pre-trial? It seems like he's doing exactly that. And he's trying to defend and cut out as much of that as he can pre-trial in order to not have to fight it in the middle of trial, because I think he knows it doesn't go well when you do it that way. The problem is most of these are losing arguments, and I think he's taking a lot of time and resources to fight these battles that I think they have some good arguments. I think there is some good evidence on the Commonwealth side that they can win at trial. I mean, I think that's just a fact that they can win at trial, right? Because there were at least some jurors that were going to convict on at least some counts, right? We can just say it that way, or even lesser included. So they can, but again, I think they're focusing on the wrong things if that's the way that they want to go, just legally speaking. Nicole said, why is the defense not harping on receiving the video evidence of Higgins after the trial? They said videos delete every 30 days. Reminds me of Baldwin. So one of the things the defense mentions here is, Judge, this is so frustrating. We've got so much going on. The judge is like, can you have this motion done by Friday? He's like, no, Judge, because we have all these things popping up. We got all these Daubert hearings for experts that already testified in the first trial. It's impossible for us to be handling all this. So maybe that's why. Maybe it's in the works. I don't know. I may have missed it, but did Judge C ever rule on the prosecution can obtain Karen's parents' cell phone information? I have not seen that yet. If I have, it slipped my mind. Anybody in the chat, if you've seen it, will you let Christy know what that answer is? All right, let's see here. Let's jump ahead a little bit. So he asks, why did the 2:27 a.m. search disappear? We don't know.
Look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to our.
This is the request to hide. He's like, this was an interesting request because in her initial opinion and affidavit, she used all these programs. But in this request to misHide, this is what was asked of her.
Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Cellebrite just went back and for some reason deleted it.
So basically the Commonwealth said, just go look at Cellebrite. Don't look at the other ones because everybody knows Cellebrite's not going to have the 227. Now we know on cross-examination, the defense is going to say the state better not be foolish enough to not ask her about those other tools on direct, but they can talk about how Cellebrite's the best and the leader and the one we should all listen to and believe. But they only asked her to go back and look at Cellebrite, which not a great look. Now, Brennan responds to this and said, this was just an update. It's just a supplement. It was a narrow request. It's not a brand new opinion.
She says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp, the determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite physical analyzing.
So are you telling me that we should have a hearing?
Your Honor,
The judge is like, oh, Mr. Alessi, it sounds like you think we should have a hearing as well. He's got to say no to that quick.
there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement.
By the way, you can say whatever you want about him repeating himself. This is how quickly he thought. He repeated himself once, which is, this is him thinking of his answer, right? There's no need to have hearing, Your Honor. There's no need to have hearing, Your Honor. And now he's got the argument. He's figured out how he's going to argue, and it's a good argument.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So
That's the crux. That's the crux of this entire argument and why this should be a pretty easy answer for Judge Cannoni at the end of the day. But there is a rebuttal, and then there's a reply, and we're going to watch most of that. Basically, Brennan starts out by saying they're twisting data, and Green's opinions are reckless, and he didn't even test his own hypothesis, so we will do it for him. But let's listen to kind of the end of Brennan, fully what Alessi has to say, and then most importantly, what the judge has to say at the end of all the arguments, because it gives us a very good indication as to which way she may be leaning in this case.
He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag value? Who manipulated it? And that is the MO. Blame any.
So I'm going to point it out, even though this is unfair because I know what's coming next. He said, what is the hashtag value?
What is the hashtag value? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in.
So did you hear what he said there? This is the defense's MO. Blame everyone, basically, even if you have no evidence. And when the government knocks him down, just move on to the next one, basically. We'll listen to it one more time to get his exact words. But he's acting like the defense is lining him up. The government's knocking him down, but he does not want to do this at trial. That's why he's doing it now.
Just articulate who. Be like a ghost. And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyatt next week or even with at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
A little knowledge is dangerous. He comes out with the haymaker, basically knocks Brennan out. Check out Yannetti's face. I'm going to back it up again. So he comes out with this this guy's quick, unless he's quick. Watch Yannetti's face.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been marked.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth,
Did you hear that? It sounds like it may just be a difference of opinion. And what that means is it's over for the Commonwealth as far as this issue goes. And I may be completely wrong. She may not even give a hearing. I thought she would give a hearing. But that comment makes me think she is not even going to give a hearing on this issue to the Commonwealth. She's just going to outright deny it. That would be my guess. And Josie Lou said, Bev just updated the docket. She made a decision. I don't know what that decision is. But if she made it that quick and this was her opinion a couple hours ago, to me, I'm pretty positive she's going to deny the objection. She's going to let this witness testify. I'm pretty positive about that. I thought she would give a hearing, but after these comments, now I kind of think she's not. Okay. So Mary said she's not giving a hearing. She just updated it. Okay. Denied the hearing. Okay. All right. All right. Not surprising now that she made those comments, but I was wrong when we read the initial motions. I just assumed she would. Lots of judges do. So kudos to Bev Canoni. I don't like calling her Judge Bev. Judge Canoni. Congratulations to everybody that guessed of what she was going to do. Good job by you. And she did the right thing, in my opinion. So there we go. That was fast. But let's listen to just a little bit more, a couple minutes more, to hear everything the Commonwealth is doing in this case, because there's some little nuggets as to what we can expect from this second trial.
I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep
Yes,
next
thank
week and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or in the process of being turned over. There was one further report. We've retained Dr. Wolf as a neurologist. I'm waiting for his report. He is away.
So good question. Angela said, hearing not, but will he testify? The fact that she's not even having a hearing is an even more of an indication she's going to allow him to testify, because this is just a difference of opinion.
Expectations, I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right.
The
So,
analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whiffen have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It has all been Bates numbers. It hadn't been before. It's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers, and provided everything that I've come across as soon as I come across it.
all right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This one took back to order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the Attorney's Office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I think it's a very, very liberal and broad view of what I would potentially want if I was defending the case. And I've provided that again on the seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have the discovery meet 30 days after I complete mine, which will be next week.
So discovery is still ongoing, but the Commonwealth has a neurologist that they hired that's going to give a report. They've done another witness interview, which he ends up saying is inconsequential. They have a dog bite expert. The accident reconstructionist is done. Pretty interesting. A lot more information than the last time. A lot more offensive. They're on the offensive here than the last time, right? They've got their own dog bite expert. Does sound like they're fighting to defend some of the defense's claims, but I'm not going to say that now. Number two, the neurologist. I have some ideas about what a neurologist could testify to in this case, but I'm not going to guess. We'll see what the neurologist ends up saying from his report, but definitely more. And they're going to have a better accident reconstructionist. I think we can all agree on that Trooper Paul's was not the way to go and not the best move. So from my perspective, this should be a positive feel for the Commonwealth, for people who think Karen Read is guilty, that they are doing all of this. They have all of these experts. Now, the defense also has experts that are more prepared this time, like Dr. Russell and Dr. Green or Mr. Green. And they know what the Commonwealth experts are going to say, so they can prepare on how to respond to that. So both sides are getting a better crack the second time around. And we're just going to have to wait and see when it gets to trial at who presents a more compelling argument and which side the evidence and the facts actually point to. And will the jury feel the same as the general public once we watch the second trial? Now, another very interesting thing happened at the end of this hearing, and that is the Commonwealth opposed paying the expert fees. I want to read that motion. I haven't read it yet, but I wonder if they just oppose like that you should dismiss the case, or that they did it on purpose, but they actually are going to pay the fees, because we've had cases where the defense is like, yeah, we screwed up. We're going to pay the expert fees. But they're opposing it. So were there some factual inaccuracies on the defense? Are they going to say there was from the defense side? I don't know. I want to see this. The judge also said, hey, defense team, you guys mentioned a motion to dismiss. Can you please go ahead and file that motion to dismiss by Friday? And the defense is like, no, judge, we've got all this crap going on, especially with all these new Daubert motions. We can't file it by Friday. And the judge is like, okay. But the judge said, if we don't have the evidentiary hearing in this situation, do we really need 2 days of hearings this week, Thursday and Friday? And everybody agreed no. So now that there's no hearing, we've got more time to handle other things. And the judge said she wants to at least discuss this motion for expert, or motion to dismiss, or motion for expert fees. I'm not sure which one she said. She wants to discuss some of that by Friday. And the defense is going to be able to review by next Friday. The defense is going to be able to review the Commonwealth's opposition, which hopefully we'll do next week as well. And we've got more hearings next Thursday and Friday in this case. And stuff is heating up because we're what? February, March, 2 full months away from this trial starting. I can't believe it. I can't believe it. It feels like there's so much that still needs to happen with the new team on the case. In my opinion, Hank Brennan is attempting to try the case in front of the judge instead of the jury and get her to side with him and totally defending the McAlberts. So, I mean, maybe when it comes to certain pieces of evidence, but he knows that she's not going to be the ultimate decision maker. But if she can limit what evidence comes before the jury, she can definitely have an effect on the result. So we'll see. ASAP trial is fireworks today. Browse X, absolutely crazy. Yes, I have been. And I'm still listening to Cross. I haven't even recorded the podcast for Monday yet. Usually we record it earlier in the week because I want to get everything that happens in that trial up to date. If you guys aren't watching the ASAP Rocky trial, you really should. It's incredibly interesting to me, and it just gets better and better with the lawyers involved and the judge and the victim on the stand. So make sure you guys hit this like button. Make sure you are subscribed to our channel. And keep me posted as things pop up in the Karen Reed case. If you get your hands on some documents that you have questions on, DM them to me on Twitter, tag me in whatever post or X, whatever it's called now. But I appreciate you guys being here with me on this Friday afternoon. I hope everybody has a beautiful weekend. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.